Suvrojyoti Gupta sir, and all the participants to the legislative drafting, public policy making, and legislative analysis jointly organized by Sambhav Initiative and Pro Bono India, where today's session is all about the law and public policy. I, Divyanshi Rathod, delegate of Sambhav Initiative, and today, moderator of this session. Thank you all for joining us this evening. Before I move forward, I would like to mention that the last few minutes of the session will be reserved for the Q&A. It is my privilege to introduce our esteemed dignitaries. Suvrojyoti Gupta sir is an associate professor at OP Jindal Global University. He completed his first degree in law from the NUJS Kolkata in May 2006. Between 2006-2009, he practiced as an appellate litigator, primarily based in the Supreme Court of India and the High Court of Delhi. During this time, he was attached to the chambers of Miss Minakshi Arora, advocate on record and standing counsel of the Election Commission of India, and he worked closely with the Election Commission of India in sensitive matters like the challenges to the Delimitation Act, explosion of MPs, Office of Profit Bill, and among others. He has appeared as junior counsel and was connected with all stages of many high profile matters before the Supreme Court of India and the High Court of Delhi. His practice areas included commercial litigation, arbitration, constitutional and criminal law. Between 2009 and 2010, Mr. Gupta sir has successfully completed his LLM in international business law from National University of Singapore. During his college days, Mr. Gupta sir was one of the student editors of his university's law journal, Indian Judicial Review. He contributed a number of articles in publications like Indian Bar Review, Journal of Intellectual Property, and Criminal Law Journal. His research interests include commercial law, arbitration, international trade law, constitutional and legal regulation of emerging technologies. We are deeply honored to have you with us today, sir. Over to you, sir.
Okay, can you hear me?
Yes, sir.
Yes, sir.
Okay, so thank you, Divyanshi. Thank you for the introduction. And I also really enjoyed the earlier session about these two legislative drafting that the professor had contemplated. So the topic that I am going to discuss today is law and policy, interplay and intersection. So I'm very sorry that I did not have a chance to make a very detailed slide because I was because of a slightly late notice, but I would try to be slow and try to go point wise so that we don't miss out on anything, right? So first of all, let's start with what is law and what is policy, right? Law is a system of enforceable rules created by custom, legislative bodies, courts, or regulatory authorities to govern behavior and resolve disputes. So this is the technical definition of law. If you look into Article 13, you will see that a law is defined in very similar terms in our constitution as well. Policy, on the other hand, is a set of principles, guidelines, or plans developed by governments, organizations, or institutions to achieve specific goals or address social issues. Right. So you can think of policy as something which converts information into an objective. Like, for example, we understand that there is a lot of dowry harassment in the country, right? So we understand that dowry is part of Indian social structure, and therefore, and this sometimes leads to criminal attacks on the brides. So this is information, but what to do about it? So this is where the policy comes. When you convert information into a set of objectives and into an action agenda, you get it policy, right? Now, remember, policy does not have to be formally articulated. Like some policies are formally articulated, some policies are understood, right? You cannot articulate all policies. For example, what exactly is the nuclear posture of the country? So we have something called a national Indian nuclear doctrine, but that doctrine is really only covers just certain aspects of it, because to do so would be to give away your defense, right? So not all policies in the country can be articulated. So you have both formally articulated policy. The example of that would be like the national policy, national AI strategy would be an example of a formally articulated policy. And there are many, many kinds of policies which are there, but not in terms of a formal document. Now, policy is always, I think it is a problem from the point of view of the lawyers, that policy is almost always politically determined. That is to say that you, like, let's go back to our original example, like dowry, right? So we know that dowry exists, we know that dowry causes consequences, but what do we do about it? There are a couple of options. Like one, of course, you just ban it. You just try to create criminal sanctions, something that we have done. But you can also try to treat this as a kind of property transactions and try to evolve methods like, say, what, like, say, like the prenuptial agreements you have, something like that. So you can deal
Varadakshina.
with it in two different ways, right? What you do depends on your political ideology, right? But however, the court is supposed to be blind to politics, and that is a problem that I'll come back to later. Now, why do we why would you want to articulate policy? Like the modern governance tries to have a more articulated policy about at least about all social and economic affairs. Why? The reason is very simple. It's a collaboration device. Like the state is like how many employees, how many agents does the state have? Millions, right? So if they are not on the same page, they cannot collectively act on something. So this is why modern trend is towards articulating them formally. And that is good from the point of view of us lawyers. That's a great thing, right? So law and policy has what I would call a gear relationship. That is to say, one moves the other. So policies would influence the laws, how the laws are made, how the laws are read. But on the other hand, laws can also influence the policies. Like certain things can evolve over a period of time through judicial or other deliberations, right? Now, the policies are enforced in two ways. One is, of course, through executive actions. So you have the agents of the state who would be executing a policy, would behave in a certain way, and that would be incident on what the particular idea that the state has, right? The other is a legal mode of enforcement. We can also enforce a policy through a law, right? Now, how do we enforce policies? There are three methods which we generally use to enforce it. One is what we called a nudge. A nudge basically means a behavioral incentive of some kind, an indirect behavioral incentive. The opposite of nudge is called a sludge. Sludge basically is a behavioral disincentive that makes you do, that basically discourages you from doing something. The third is a fiat. The fiat is the most direct. That means there's a direct order, there's a direct enforceable order from the top. Like take a very simple example of what nudge, sludge, and fiat can be. Suppose your father wants you to wake up early in the morning. What can he do? He can buy you a puppy. The puppy will wake you up in the morning because the puppy has to go, right? The puppy is to, we have to take it for a walk. So that's a nudge. He's not asking you to get up. He's not forcing you to get up, but he's creating situations where you would. The second is called, what would be an example of a sludge? A sludge could be, for example, when you have breakfast, you particularly enjoy the orange juice. So the father makes sure that the orange juice is over by 7 o'clock. So if you don't get to breakfast table by 7, no orange juice for you. So that's a sludge. The fiat is a direct order. The fiat, the dad says, ki, dekho bhai, get up. Otherwise, you are not going to have a good day. I'm going to give you a thrashing. I'm going to cut your allowance. Your negative consequences will follow. So that's my order. You will have to do it. Okay. So these are the three methods that we have. Now, uh, so this is how we enforce policies generally, right? Now coming back to law. Okay. Now law we say law as a billiard ball. Law is something that just operates in a single manner. That's not correct. There are different kinds of law and they differentially enforce policies, right? For example, you can have common law. What is common law? Common law is basically customary law that has been recorded by the courts over a period of 100 or maybe past 500 years, right? So that is common law. So that is one. Then you have legislation. Legislation is, of course, something made by the parliament or by the state legislatures. This is done in a particular way. This reflects the will of the people. Then you can have an ordinance. Ordinance is basically a direction or an order from the president or the governor, and that has to also come from a certain way. Then you can have case laws. Case laws are basically judge decided law. So if there's no rule, there's no legislation, the judge over a period of time develops it. Case law and common law are essentially basically just merge into each other. And you can also have delegated legislation. Delegated legislation is basically regulations which originate from administrative bodies, right? So there are different kinds of laws that we have. All the laws would have something called, would give you a system of rights and duties, right? So right, the best way to understand a right is a trump card. So if you have a right, then you can enforce the right no matter how inconvenient or how costly it is to do so. Okay. And if you have a right, then there is a corresponding duty on someone. Okay. Uh, rules and acts also have the law also have like how the laws are structured are also divided into what we identify as standards and rules. A standard would be something, a qualitative statement. For example, if I say that you drive on the bike lane at a reasonable speed, so that's a standard, right? I don't tell what reasonable speed is. That is contextually understood. Or I can give you a rule. A rule is that I give you a speed limit. I say that don't exceed 25 kilometers per hour in the bike lane. That's a rule, right? Then finally, all laws would have an enforcement authority or an enforcement procedure. Okay, so that can be the civil court, that can be the criminal court. They can create a tribunal for that, but there is going to be a method for that. Okay. Now, coming back to the interaction between laws and policies. So, uh, legislation for like laws and policies don't have any one-to-one correlation. That is to say, like if I have a policy, it's not necessary I'm going to have an act which is just going to reflect that. So, for example, you can have a legislation that would reflect multiple policies that the state has, and you can also have multiple legislation reflecting the certain policy that the state does. For example, if you like, just to give you an example, suppose if you look into the Arbitration and Conciliation Act, right? So, what are the policies that the act reflect? The act reflects, first of all, it is giving effect to something called a New York Convention. So, it is basically honoring a country's international commitments. Then, it is encouraging ADR, alternative dispute resolution. Then it is also giving effect to the state's policy of promoting ease of doing business, because by making it easier for people to enforce contracts, you enhance their ease of doing business, right? So that is also a policy which the Arbitration Conciliation Act supports. Okay, so there is one act which is reflecting multiple policies. Similarly, if you have say cybersecurity, cybersecurity would be reflected in, say, the Information Technology Act, the 2000. It would be reflected into provisions of the BNS. It will be reflected into, say, the Data Protection Act, right? So multiple acts would be reflecting that one policy that the state have. So there's no one-to-one correspondence, but you cannot actually there's no policy that you can actually enforce without completely without the help of a law. I'll come back to this point later, a little later. Right. Now, so what is the mechanism for law to influence policy or to give effect to policy? Now, that depends upon the nature of the law, right? So, if it is common law is evolutionary in character. That means it has evolved over a period of time, right? So, social policies, of course, change over a period of time, right? So, for example, the
Sir,
common law can,
hello, am I
yeah,
audible, sir? Sir, actually your PPT
yeah.
screen is stuck at slide number 4.
I know. I have not made, as I told you, that I have not been able to make a full PPT, right? So forget that. Okay. So as I was saying, uh, so common law is evolutionary in character, and policies, of course, change. So, for example, the common law would say the common law at some point of time required that on marriage, the wife loses her right to have any kind of property. Right. Why? Because that was the social expectation that was there for 500 years. So that was there. It did not change. So even if times have changed, the social policy has changed, the common law does not automatically change. So what happens in that case? You have to correct the common law with a legislation. And that legislation would be read through what we call a mischief rule. Okay. Now, what is the mischief rule? Mischief rule, I think there are many of you who are either advocate or a law student. Mischief rule, that originates in the Hayden's case. Mischief rule requires that what was the common law before the rule? What is the mischief that the common law, mischief that is defect that the common law did not provide? That the remedy, what is the remedy that the parliament provided? And number four, what was the reason for the remedy? So basically, if you have a situation where the common law has ceased to reflect the social policy, you would have to correct it with a legislation. And that legislation would be read in terms of what the social policy is and what is it that the parliament tried to do. Okay. Now, delegated legislation is my favorite from the point of view of policy for the simple reason that delegated legislation is made in a way that it almost always will reflect a policy. In fact, they make the whole idea of delegated legislation is for particularly economic policies to reflect the current mindset, right? So, for example, if you have something called the SEBI Act, right? The SEBI Act, you create a body called the Securities and Exchange Board of India. And the Securities Exchange Board of India is given the power to frame rules, guidelines, regulations, and they make this congruent to whatever the economic understanding that the state has currently. Right. So to that extent, you can say delegated legislation or regulations of this time are always generally reflective of the policy itself, contemporaneously reflective. That means the policy as it stands today. Okay. Uh, Now the third is of course common law. That is the third is of course judge-made law, the case law. Now there we have a slight problem. See, the understanding that we have, like the understanding that was there in English law and just flown into Indian law, is that the judges do not make the law. Judges simply read the law. That is to say, just interpret the law as it stands today. Right. So what would you do if you have a case law which is reflecting an older ideal of policy and everything has changed, or there's a policy, uh, suppose there's an old case law and now you have a new policy. Could be formally formulated policy also in a document, like say for the AI strategy, right? What would you do? So one way you can deal with the situation is, of course, you read it purposively. You see what is the object of the rule, what is the object of the policy, and you change it in a way. Sometimes when the judges, like judicial decision making is hierarchical, right? So if you have a Supreme Court decision, the High Court cannot overrule it, right? So what they would do in that case is that if they see that the judgment is not reflective of the current social policy, they would often try to distinguish it. That is to say, they would say, okay, this does not, there is a difference in that judgment and the present scenario. Okay. However, there are situations where the judge himself might be creating policies, right? And this is where it gets a bit complicated. Um, this would particularly happen into certain kinds of judicial proceedings, for example, into public interest litigation, right? So, public interest litigation, the judiciary would, for example, I think many of the law students here at least would know of this case, T N Godavarman, right? T N Godavarman versus Union of India. So T N Godavarman created an entirely new forest protection paradigm, which was not reflective of the forest protection policies of the state at that point of time. So they are basically going over and above what the state has done. So if you think that the state and the elected representative of the people have the prerogative, have the sole prerogative of making policy and the court should just enforce it, then you would find this to be problematic. And this was really a huge issue in this country. I mean, you won't remember it because you are so young then, many of you. 2014, when there was the second UPA government, there was increasing interference by courts in the nation's coal allotment policy, spectrum allocation policy, environmental policies, and the politicians started taking the view that the court should not enter into the questions of policy at all, right? This is not strictly true. I mean, the courts do have the prerogative to do so because, I mean, in real world, like this notional distinction we make between interpreting a law, interpreting the state of the law, and creating a law, or following a policy and creating a policy, it's very difficult to make, right? So this is like a thin vanishing line, right? Now let us come to the question of statute law. Statute law, as you know, comes from the parliament or the state legislature, right? So they have been legislated and they are done with an a priori reasoning. Matlab, like what I mean to say, that suppose you are framing a national artificial intelligence law, right? So you already have access to the national AI strategy, and you are making your law based on that formulated strategy you have. So to that extent, that text should always reflect the policy, right? Now, how do you make it? Because as I said, that um, policies are an ever moving point. So there are certain statutory interpretation rules that we have created uh, to read, uh, to create a congruence between how legislations are read and how policies are formulated, so that they should be together, right? That if you make laws in a way, you make policies otherwise, I mean, your social life would be a complete mess, right? Your society, your economy would just fall apart. To prevent that, we have certain rules of statutory interpretation that I can share with you. The first is the emphasis on the preamble. Now, the preamble, basically, as you know, the preamble is where you give a statement of objects and reasons as to why this act has come to be, right? So the preamble expresses the scope and object and purpose of an act, right? Um, that is, uh, and this is how you interpret the intention of the legislature. What is the policy behind this act, right? So this is well understood in English law. The case I was referring to is the case of Brett versus Brett, which is a 1826 case. I mean, this is old understanding, right? And this continues to hold good. The second is that the preamble can be used to interpret ambiguous provisions. So as I was telling you, that a statute works with both standards and rules. Rules are very cut and dry, like rules you understand. I tell you, 25 kilometers per hour, don't go above it. But if I have a standard that says go at a reasonable speed, how do you understand the reasonable speed? Then you should probably go back to the preamble of the act. The preamble of the act expresses, the preamble of this act states that I have created the statute on National Bike Lanes Act, and this National Bike Lanes Act go back to National Transport Policy of 2020, which required that you should have a safe space for bikes, right? So if you read it that way, you will see that if you exceed the speed of say 25 kilo, like you can show statistically, if you exceed the speed of 25 kilometers per hour, then there are higher chances of accident. Now, if your policy was created with an idea to create safe space for bikes, then that is the only interpretation you can have. So that's one way to do it. Now, I would say it's very sad that in India, many of our acts do not have proper preambles. We do have sometimes have a one-line objects and reasoning at the top, but that's about it. Right? Why? I don't know. Maybe it's just inattention. Maybe because our lawmakers do not understand the importance of preamble, or maybe because I don't know that maybe some legislations they just wish to keep intentionally vague. The preamble making in Indian statute is not very common, just one-liners, right? In certain English law, but I have not seen an Indian law like this. I think I can show you this. You would have a whole, see, this is how, for example, a preamble in an English act. This is the Legal Services Act, which sets up how the legal services market in UK is to be organized. And you see how detailed it is, right? Uh, then you'll see that in this act, yes, this is the act. Can you see this? In part one, they have written regulatory objectives. And if you look into these regulatory objectives are taken directly from something called a Clementi Commission report. That Clementi Commission report was basically a commission that was formed to suggest reforms to the English Legal Services Act, right? So if you have something like this, it makes the job of the judge very easier, much easier. But Indian statutes, we just don't have them, right? I have much to say about Indian statutes, how we make them. That's very unfortunate and inattentive way we make these things, right? Now, both preamble and this objects and this regulatory objectives can be identified as something called internal aids to construction. Internal aid meaning that they are within the statute and they are helping you construct or understand the meaning of the statutory provisions, right? However, sometimes it is possible for a policy to be treated as an external aid, meaning that suppose you try to understand what is going to be the true and proper interpretation of a certain section of the Digital Data Protection Act, right? You don't understand it. So what you can do is you can look into the National AI Strategy. National AI Strategy is of course not part of the act itself, right? It's something external. And you would read this and understand these two provisions in harmony with each other, right? So that is treating a policy as an external aid. Now, certain policies, but not all policies, can be treated as what is called a public policy. Public policy within quotations. Okay. So the thing about a public policy is, public policies also sometimes called mandatory rules. So a public policy are certain principles and standards that are of fundamental concern to the society, right? So they are very fundamental. Not all policies can be treated as a public policy. Only some of them can be treated as a public policy, right? Now, what are they? What are mandatory and what are just out there? That's for, I suppose that's for the judiciary to decide, case by case basis. Now, if certain policy objective is identified as a public policy, what happens? If you make any contract in derogation of that, if you have an arbitration award in derogation of that, or for that matter, any executive action which is in derogation of that, may be set aside or voided, right? So if you have policy this, which should be reflected in your statutes, public policy have a slightly higher standing, right? Now the problem is, of course, that who decides? The judge decides, and there does not seem to be any satisfactory, how shall I say, satisfactory system as to decide what a public policy is, which has resulted, which has led to one very famous judge. I hope you have heard his name, Lord Denning, comment that public policy is an unruly horse. So the judges are sometimes reluctant to identify something as a public policy, right? I'm not going any more detail into statutory interpretation because this is not what it is about. I mean, you have whole sessions like which are devoted to it. But just understand a policy may have this higher standing as that. So public policy you would find in section 28 of the Indian Contracts, sorry, section 23, I think, of the Indian Contracts Act, section 34 of the Arbitration Conciliation Act, various places in administrative law, you would also come across that term. Right. Now, finally, how, so this is reading. This is to bring law and policy on the same page. But how is it enforced, right? How a policy is enforced. So, two ways you can. Of course, you can just create an enforcement agency, right? So if you have crime, the state goes ahead and enforces it through police, through CBI, through whatever verticals it have, right? But you can also create a clever way to do so, and this is known as a private enforcement of public right. So they create a right and they give you the opportunity to enforce it yourself, right? So you can ask, what is the point? I mean, why not just have an agency? The point is that it makes it cheaper for the state, because if you need to have suppose it's a policy of the state to enforce digital privacy, right? And they have a entity to enforce it. So the state, the country has like 1.2 billion people. So 1.2 billion cases will they go? Cannot, right? So I give the right to the people can come ahead and enforce it themselves. So this is known as private enforcement of public rights. American law is particularly well known for this, but since the early 90s, we have increasingly incorporated this into our statutes as well. So this is also our way of sort of giving, I like how I call it. You can think of it as a kind of bounty hunting. You can say just whoever go ahead and enforce it. Okay, so that's one way. Now I think I won't take any more of your time. I just finished with one question that I often ask students at the beginning of every semester. So suppose, let's do a mind experiment. Suppose tomorrow there's a comet that hits Earth and wipes out human civilization. Now you have three survivors, one doctor, one engineer, and one lawyer. So it is very self-evident what the doctor and the engineer might be able to do. So what is it that the lawyer is doing? Right. So I mean, this is not, you are not here physically. So I would have liked to hear your response as to what the lawyer might do. So I just shared with you what my students say that the lawyer is good for. So one student very proudly said, "Sir, the lawyer would be needed for creating a civilized existence, to recreate the civilization, right?" I said, yes, but you know what? That for most part of humans' existence of art, there wasn't something as you'd say, cohesive as a law. So there are many societies that, though they have some kind of laws, but they are not cohesive as that, right? So you can have a society which is guided by power, guided by religion, can give just as good example. Okay, so that's not it. The second one, one student told me that, no, sir, the lawyer is no good. You should, the doctor and the engineer should just probably eat up the lawyer, right? So there will be lack of protein in that apocalypse, and the lawyer is only worth that. I said, Teko, my view, neither of this is correct. The point is that when you have a society which has reached a certain level of complexity, you need somebody to negotiate this complexity. You need somebody to make sense out of it, right? So the lawyer does it. That is the duty of the lawyer. That is the duty of the law courts. That is the duty of the entire legal structure. If you don't have this, then policies would be just that, like floating in ether, empty space, right? No policy would eventually have an effective outcome, right? So with that, I thank you all for inviting me here, and let me hear any questions that you might have. Thank you.
Thank you, sir, for your wonderful session. Now we open the floor for question and answer. If you participant have any question, you can raise your hand and directly ask to the sir, or even you can write in the chat box.
Sir, may I ask one question to you?
Yes,
Yes.
sure.
Yes, thank you very much, sir, for your session, sir. Sir, initially you have pointed out that law influenced policy and policy also influenced the law. So,
Hmm.
sir, can you give us any illustration wherein a law influenced the policy? And that is my first question. And the second is that uh, as you have also pointed out that judiciary also play an important role uh, in regarding the policies. So again, can you please give us illustration wherein judiciary has motivated the roots of the policy? These are my two questions, sir. And whether can judiciary talked about the wisdom of any policy or not?
Right. So I have excellent questions, though they are not related to each other. So I'll take them separately. First of all, the question you asked, we can see how law policy is enforcing law, but is law also influencing policy? Yes. Dekho, law is just the collective experience of people, right? So, and to make a cohesive set of policy, as I say, is essentially converting information into an objective, right? So, the experience of law is what is giving rise to policy. So, for example, just think of it this way: it was the social policy, like the dowry example that we gave. The dowry example, it shows that the state is aware that there is something called dowry in Indian society. The state is aware that it is giving rise to criminal conduct. Therefore, the state comes up with a policy against the dowry, which is reflected in criminal law, how the family law is organized, and various other things. They also create anti-dowry, like Women's Commission and all, who enforce kind of anti-dowry law. But then again, we put that policy in our operation, right? So it seems that that is true, that while this abuses of dowry is correct, but it is also true that some people are abusing the law against dowry itself, and how they are doing it, right? So this experience, this evidence is coming from law itself, from in the legal discourse itself, right? And based on this evidence, the state would correct itself. Will it absolutely abandon the law against dowry. It won't. It cannot, because the harm that it is causing is still there, right? It will modify itself. So this is think of law and policy as a continuous feedback loop. So policy is getting feedback from law, and law is trying to make itself congruent to the policy. Okay. So like, is that it, or do you like me to cross question on this one, number one? Okay. The second question you asked, what did you said?
Sir, can you give us any illustrations wherein the judiciary has paved the way for any
Okay.
policy?
Okay. So this goes back to a wider question. What is the role of judiciary in governance, right? So like this separation of powers, as we understand, separation of powers means what? That legislation is with the legislature, executing that legislation is with the state, that's the government, and reading that legislation is with the judiciary. To that, if that is the scheme, then judiciary cannot do anything more than interpret what the people's representatives have passed. But as I said, that legislation is a centralized activity, right? So you have this 500 odd people who sits there and you pass a law. So every small thing, can they pass a law about? They cannot. There will obviously be gaps, and that gap would have to be addressed by judiciary. And this gap would increase if, as I was telling you, policy is always politically determined, right? So think of what India had between 1990 till say around 2014. So the parliament was divided into small factions, like smaller groups. So you had this alliance governments. So you have an alliance, you cannot really proceed very fast on a lot of things, right? So that created a gap, and judiciary stepped in and created what is known as a good governance. So the example, I mean, there are so many examples, and all of them actually goes back to one particular kind of judicial proceeding, what we call public interest litigation, right? So for example, right to emergency care, then your Delhi CNG, right to education, even right to education first started moving through the courts, and then only it become a policy, and thereafter it become Article 21A of your constitution, right? Forest policy, I gave you the example of Godavari. So that was over and above whatever the forest policy was. Environment, right? So many examples. So there, the policy was created, this governance issue was addressed by the court. And direct execution of policies, I think the particularly interesting case that you'd find of particular interest is the case of the CNG, Delhi CNG, right? So I think many of you may not have been born then. In early 2000, Delhi there used to be diesel autos, and they were very polluting. So the Supreme Court through fiat just changed them all to LNG and CNG, right? So this is a one very crucial and particularly glaring example, the court stepping into policy. Sometimes it does not work out also. The coal block, I don't know if you remember the coal block cancellation case and the telecom spectrum cancellation case. So there also they stepped into policy, and they there did not, it didn't turn out right, because all the arbitrary cancellations that they did gave rise to investment arbitration against India. And we had to shell out like billions of dollars to this foreign investor because of this cancellation. So it does not always work out that well. What was your third question again?
So my third question was whether judiciary can enter into the wisdom of any drafted policy.
Usually, the judiciary does not, because there are decided case laws that says that the judiciary has to follow the government policy, right? However, remember, the judiciary is the ultimate custodian of the constitution. So suppose there is a policy which the judiciary finds violates either the fundamental rights or the basic structure of the constitution or any particular provision of the constitution, it can always step in, right? It is no defense for the state to say, we had a policy, right? Because as I said, the concept of rights, right? When you have a right, right is a trump card. and the right overrides everything. Right? If the judiciary finds there's a fundamental right, there's a basic structure, the judiciary can push back against the policy.
Thank you very much, sir.
Now I would like to invite Ms. Hiranshi Shah ma'am, founder of Sambhav Initiative and a young member of Singapore International Arbitrator Center to deliver vote of thanks. Over to you, ma'am. Thank you, everyone. Have a great evening.
Thank you.
Thank you, Devanshi. First of all, on behalf of the Sambhav Initiative and Pro Bono India, sir, I would like to extend my deepest gratitude, not only just accepting our invitation, but also for this wonderful session. We were honored to have you, and also we was very grateful that you accept our invitation on very short time. So thank you so much, sir. Also, I would like to thanks all participants to join us today. Have a great evening ahead. Once again, thank you so much, sir. We look forward to host you in our next capacity building programs. Thank you, everyone.